So, good morning, everyone, and welcome back to our weekly webinar series. On this auspicious occasion, I wish everyone a very, very happy Ganesh Chaturthi. Over to Anil sir to take this forward.
Thank you, Ankit. Welcome to 126th episode of AAA Weekly Webinar Series. As Ankit said, wishing you all a very happy Ganesh Chaturthi and hope and wish that you all are blessed. Since the subject that we have chosen today is definitely in demand as of now. There are many resolution plans which are under implementation, and there are clarifications required on the role of monitoring committee and also powers of the monitoring committee. So we are going to discuss today all the provisions regarding monitoring committee and also various judgments on monitoring committee, what are the powers of monitoring committee, who all can become the members of the monitoring committee, and like various issues which actually would revolve. Now, with this, we actually can start saying that the introduction, in case we try to introduce the monitoring committee, it is normally defined as the monitoring committee under the insolvency law is a vital mechanism set up to oversee the successful implementation of the approved resolution plan. It comprises representatives of successful resolution applicant, also other experts, the representatives of the financial creditors, means committee of creditors, and also the resolution professional. But the resolution professional is not mandatory as per IBPI regulations. However, the purpose of the monitoring committee is to monitor the progress and with 100% transparency and adherence to the agreed terms and conditions of the effective resolution plan. Now, when we see this critical and all the provisions of the insolvency law under the code, so we first of all go to section 30, which says, which section 30 is the mandatory requirements in a resolution plan. The section 30, subsection 2 says that the resolution professional shall examine each resolution plan received by him to confirm that each resolution plan, like there are sub clauses A, B, then C says, provide for the management of the affairs of the corporate debtor after the approval of the resolution plan. Then subclause D says the implementation and supervision of the resolution plan. How the resolution plan will be implemented and how the same would be supervised. So from this particular subclause, the concept of managing committee arises. Then like we have seen, even in one scenario that you would see in the same section, there is an explanation, and that explanation says that the if any approval is required under the Companies Act or any other law for the time being in force for the implementation of actions under the resolution plan, such approval shall be deemed to have been given. Although this is then again we see the section 31 of the IBC, which says that if the adjudicating authority is satisfied that the resolution plan as approved by the COC and under subsection sub 4 and subsection of section 30 meets the requirements of section 30 subsection 2. That means the adjudicating authority also have to see that the requirements are met. So within the requirements, under section 30 subsection 2, there is one requirement of implementation and supervision of the resolution plan. So this is now, this particular section says 31 that the resolution plan is binding. Now then there was a proviso which was added to this, provided that the adjudicating authority shall, before passing an order for approval of resolution plan under this subsection, satisfy that the resolution plan has provisions for its effective implementation. So that therefore it is also the responsibility of the adjudicating authority to see before passing the resolution plan, before giving an order, to assure that the resolution plans has provisions for its effective implementation. Even Section 54 capital L, which is part of the entire framework regarding pre-packaged insolvency resolution process, that also says that the implementation and supervision of resolution plan, similar provision, exactly similar provision as we have seen, is also there in Section 54 capital L as a part of the framework of pre-packaged insolvency resolution process. Now, Section 116, that is regarding the personal insolvency of personal guarantors. Implementation and supervision of the repayment plan. Here also, the resolution professional appointed under Section 797 or under Section 98 shall supervise the implementation of the resolution plan. However, in Section 116, in the case of personal guarantors insolvency, the monitoring committee is not proposed. It is only the resolution professional. Either that resolution professional will be the same person who actually was involved in the resolving the insolvency of that personal guarantor, or if the repayment plan is having some kind of provisions that the repayment plan will be implemented in the next few years, and it also of the uh, personal guarantor, then it is also required that the committee, and list the creditors can change that resolution professional only for the purpose of monitoring the repayment plan. So now we go back to section regulation 38. We go back to regulation 38. Regulation 38 of the CIRP regulations. Regulation 38 says sub-regulation 4 and sub-regulation 5. In fact, this was a recent like kind of insertions in the CIRP regulations, and these insertions, these additions were made on 15th of February 2024. Now, these regulations have actually given more powers to committee of creditors. Before this, regulations were inserted on 15th of February 2024. The general concept was that it is the prerogative of the resolution applicant that what kind of monitoring committee should be there. But now, when these regulations are inserted on 15th of February, it actually says two things. One, sub-regulation 4 says the committee may consider the requirement of a monitoring committee for the implementation of the resolution plan. It also says the may consider. But in this manner, if the resolution plan is slightly different, it is only involving upfront payment, then the committee will say that we are not interested in the monitoring committee. But there has to be some mechanism for implementation and supervision, because the regulations cannot override the code. In the code, it is written that the adjudicating authority will have to make sure that there are proper provision for the implementation of the resolution plan. Now, let us understand that in case a resolution plan is made in such a manner that it doesn't require any kind of implementation, as it will be immediately after the resolution plan is approved, it will be immediately implemented. However, according to my understanding, each resolution plan needs implementation, because there has to be some handover required from resolution professional. Resolution professional has taken control and custody of all the assets, records, documents. All that has to go to the resolution applicant. So therefore, the RP would definitely be instrumental in implementing the resolution plan. Now, the sub-regulation 5 says where the committee considers that a monitoring committee for the implementation of the resolution plan is required. The first subsection says that the committee may consider the requirement of a monitoring committee for the implementation of the resolution plan. Secondly, where the committee consider a monitoring committee for the implementation of the resolution plan is required, it may, while approving the resolution plan, decide to constitute the same with the resolution professional. One, with the resolution professional, or propose any insolvency professional or any other person as its members. So what I understand about the insertion of these two, one, that the committee may not be required, and the resolution professional itself can be said that he is a monitoring professional. So in that case, the committee may not be required, but the resolution professional will continue as monitoring professional. That's what I understand. But otherwise, the who will hand over that part has to be done. The adjudicating authority has to hand over this responsibility to somebody, saying that this the resolution plan will have to be implemented. Now, in this case, it is said very clearly that with the resolution professional, or propose any other insolvency professional or any other person as its members. So therefore, the committee of creditors has the power to propose the resolution professional as the monitoring committee member or chairman, or propose any other insolvency professional or any other person as its member. So therefore, the resolution professional may be continued, some other IP may be continued, and any other person can also be added in the, but there is not, and it is not necessary that the resolution professional will continue in case a committee is made. Then further, there is a proviso which says that provided that where the resolution professional is proposed to be part of the monitoring committee, the monthly fee payable to him shall not exceed the monthly fee received by him during the corporate insolvency resolution process. Now, this was added to kind of check any kind of malpractices, any kind of promises that a resolution applicant can make to the resolution professional, that you favor us and we will give you higher fee during the implementation of the resolution plan. So that is only to check. However, the fee equivalent to the fee that he was charging during the CIRP, that is what the IBBI is saying, that should be the fee, and that should be the maximum fee rather. There is no there is nothing on the lower side of the fee, but it is only the maximum side of the fee. But the RP has no power to claim a fee which is more than the fee that he was claiming during CIR. Now, we try to understand, like, what are the roles and powers of the monitoring committee? So how it drives the powers from the, how it drives the power. Now, the first document which gives the powers to the monitoring committee is the resolution plan. The resolution plan will define, one, who will be the, whether there will be a monitoring committee. If yes, who would be the members of the monitoring committee? And after that, the scope of work, roles, and powers of the monitoring committee will also be defined in the resolution plan. But then there are many resolution plans which are not defining these roles and powers. Roles and powers and scope of work are not being defined in many resolution plans. So all the insolvency professionals and the committee of creditors, they must see whether the resolution plan has this provisions, scope, powers, and role of the monitoring committee. That's very, very important. Now, the statutory backing that we have got is out of the Regulation 38, and also we have got the statutory backing out of Section 30 and Section 31 of the IBC. Section 31 is very clear that the adjudicating authority has to satisfy before approving a resolution plan whether there is a monitoring mechanism or not. Whether there is a supervisory mechanism or not, that is the duty of the adjudicating authority. Now, the approval of the resolution plan by the committee of creditors, where all the scope, powers, everything is mentioned in the resolution plan, mostly I have seen, in fact, I asked my team to see 15-20 orders of approval of the resolution plans and find out what are the language which is written by the various adjudicating authority, various NCLT members. When we see that the powers are drawn from Regulation 38 and also from Regulation Section 30, subsection 2, and also Section 31 proviso. Then we also see one is the approval of the committee of creditors to the resolution plan. That also gives power. And then finally, when we see the powers and ongoing monitoring, it is all is depends upon what is mentioned in the resolution plan and finally what is mentioned in the order. In mostly we have seen that in the orders approving the resolution plan, that particular paragraph numbers are given that the monitoring committee will also have the roles and powers as per the paragraph number so and so of the resolution plan. That is also which is simpler. But the duration. Now, we also need to understand what would be the duration of the monitoring committee. As per the practice, as per the traditions, the monitoring committee operates from the time the resolution plan is approved by NCLT and it continues until the completion of the resolution process. Now, what is completion of the resolution process? The completion of resolution process is when all the claims made during the resolution process are satisfied, either as per resolution plan or as per the insolvency and bankruptcy code, that the others are not having any claims now on the company. So the company, whatever company had, it has already been distributed, but the resolution plan is implemented. So whatever claims are left or not paid, those are all completely. So what we are trying to say that yes, the duration of the resolution plan is till the complete implementation of the resolution plan. Now, in case of home buyers, where the resolution plan says that the project would be completed and the possessions would be given to all the allottees. That means that the monitoring committee will continue till all the possessions are given to them with all promises mentioned in the resolution plan, with all approvals mentioned in the resolution plan. So all this has to be completed before the duration and authority of the monitoring committee is considered as closed. So that is what is the on the duration of the authority of the monitoring committee. Now, let us understand who should be the appropriate person for becoming part of the monitoring committee as member or as chairman. Now, when we see the first is the resolution professional, and why a resolution professional is important, because resolution professional is with the company at least for the last 1 year. He understands all the nitty-gritties and all the complexities of the case. He understands about the litigations of the case. He understands about the assets and documentation and records. He has taken over everything from the promoters as per the powers given to him. So therefore, the RP is the person who would be able to handle this supervision effectively. Now, the RP also understands the insolvency and bankruptcy law, also understands the powers given under the code as well as regulations. So therefore, the resolution professional would understand the implementation better than any other professional. And we assume that the resolution professional has the uh, uh, appropriate knowledge about the processes. So therefore, the best person who actually can be given the responsibility of implementation of the resolution plan is the resolution professional. Now, the regulation says that the committee of creditors can also appoint any other insolvency professional. So that is the second best choice in case the committee of creditors think that the resolution professional is either not properly equipped or experienced, or even the committee of creditors may think that the resolution professional is biased towards someone. Then they can propose any other experienced insolvency professional so that all the conditions of resolution plan is understood and implemented properly. So the second best is the person is the any other experienced insolvency professional. Now, even the Regulation 38 gives the power to committee of creditors to appoint any other person who is not even RP or who is not even insolvency professional. They can even appoint any other expert or any other person whom they trust as the member of the monitoring committee. That can be along with the RP, along with the any other IP, and even any other person. So what are the powers given to the committee of creditors? They can appoint an RP, they can appoint any other IP, they can also appoint any other person. So it is not important that the committee of creditors can only appoint their own members. The committee of creditors can also appoint an RP. The committee of creditors can also appoint another insolvency professional so that the implementation is done properly. And the committee of creditors can also appoint RP as well as another insolvency professional and another expert if the committee thinks that it is appropriate and if the committee thinks that it is required, considering the complexity and the size of the implementation. So this is the one part which is considered to be the expert. RP, any other experienced insolvency professional, any other person the committee may think. This is the one part. Now, the second part is the resolution applicant. Nominees of the resolution applicant, they would only see their interest. Resolution applicant will see their interest, they will watch their interest, they will understand their interest, and they will seek various processes, they will seek their requirements before the monitoring committee. So therefore, they are there in the monitoring committee because they will have to watch their interest, they will have to implement. Now the committee of creditors, the nominees of committee of creditors, normally the tradition is that the committee of creditors will nominate 1, 2, or 3 members who have the largest share. So their role also would be to look after their interest, to look after the complete compliance of the terms and conditions. They also have to look into the approvals that they have got from their own sanctioning authorities, and they would have to assure that the approval that they have obtained within their own sanctioning authorities, those are completely implemented as per their understanding. And in case of any dispute, any clarity on the understanding, that will also be discussed in the monitoring committee. So 1 expert or 2 expert or 3 expert, that is the option of the committee of creditors. Resolution applicant can also have their nominees. Financial creditor, the COC also can have their nominees. So like as I've already said that the RP, insolvency professional, any expert, they actually have the experience of monitoring. They have the experience of cases. they can actually be very, very useful to also the resolution professional or insolvency professional is a fully monitored professional. It is very easy to file a complaint about any insolvency professional. In case he's diverting from his role, in case he's biased towards any other member or any other stakeholder, any other member can file a complaint and that complaint would be heard. So therefore, any person, any professional who is regulated is the best for the purpose of compliance of all the provisions of the resolution plan. So the credibility of the resolution professional, the monitoring, monitoring infrastructure, and these are very, very important parts for the purpose of saying that the resolution professional is kind of indispensable from the monitoring committee. So, Ankit, at this moment, we have discussed the primary issues in the monitoring committee. After this, we are supposed to see what are the various judgments. Of course, there are many judgments. There are not many judgments from Supreme Court, and there is only one judgment that we could see from NCLT, which is talking about monitoring committee's role and powers. But there are various judgments from NCLT when they are constituting the committees. I think in case we have questions or anyone would like to see add some question, we can understand that. So
So
one
Miraj,
scenario, Ankit, also I would like to say that see one that we still need to understand in the implementation part, the bank account which is opened by the RP during CIRP, that normally continues because the most of the resolution proceeds will come in that account and it will be distributed from that account. We need to understand how the monitoring committee professional gets this power to continue with the same account. Then we also need to understand the monitoring committee is passing a resolution as if this is board of directors, and whether they can pass these resolutions for appointment of directors for other purposes also. So mostly the committee of creditors will say that you will not hand over the control and custody of the asset till the time the resolution applicant gives at least one or two tranches of the payment. That is also condition. So that means the in between period, the monitoring committee is managing the company as a going concern. So here, there are a lot of questions which we are going to discuss follow on. And however, if there are other questions which are coming in the minds of the attendee, that we can also see.
so first question that has come in is from Miraji. He says that is there any proportionate representation from COC and the RA in case of any dispute, how to resolve it and whether adjudicating authorities' intervention would be required. So proportionate representation is normally sought, and it can also be disproportionate. But yes, the idea is that a voice of any of the representatives is important. So, for example, if there is a COC, then if the COC constitutes one large voting share, financial creditor, then that person can represent the entire COC and take care of the interest of all the COC members. At times, we also see that two of the COC members want to be part of the IMC. So this way, it can be either, right? So, any your feedback on this?
So when I think the question of proportionate representation, that is all the discussions that normally we have while we constitute the monitoring agency or monitoring committee. Normally there are discussions regarding how many members would be there from the committee, how many members would be there from the resolution applicant. So in case there are joint resolution applicant, then there is also some kind of adjustment between who will have how many members. And then of course one chairman, and the most like acceptable choice of the chairman is the uh, resolution professional. However, in fact, we try to even have clauses in the resolution plan how the decisions would be taken in the monitoring committee, whether the chairman of the monitoring committee will have two votes or it will have only one vote. Then the what would be the, because the committee also can take a decision in that manner that the unless there is a consent from at least one member of the committee of creditors, then that resolution will not be passed. Or even other way, unless there is member from the uh, resolution applicant, successful resolution applicant, the no resolution can be passed. So these kind of uh, clauses are also inserted in the resolution plan so that the monitoring committee, actually monitoring committee becomes very, very important after the resolution plan is approved by NCLT. Because the entire decisions, how the funds will come, how the funds will be distributed, and especially in the case of real estate, it is very important to discuss all these issues, how the contractors would be appointed, how the project management consultancy firms will be appointed, who will appoint the internal auditors, who will appoint the statutory auditors. So all this is a dispute before a resolution plan is finalized, especially between the home buyers and the successful resolution applicant and also bankers. So this is something which I say that the possibilities of monitoring committee, it can actually have all those kind of things normally we see in the investment agreements of companies. What can the decision, what type of decisions can be taken by the what should be the size of the quorum, what kind of decisions can be taken by the committee, and how the whether 75% voting is required for following decisions or 51% voting is required for following decisions. All this is possible as far as the decision making process is concerned, and that can be provided in the resolution plan. Yes, sir. Yes, sir.
Then we have a question that whether dissenting financial creditors can be members of the monitoring committee. There is no bar, legal bar, but then
There is no
what
legal.
would be the objective of this of having dissenting financial creditors as a member of the IMC would be to maybe take care of their interest as a dissenting financial creditor.
See, the dissenting financial creditors will see the value of the assets on which they have their security interest. And they would like to be member only just to monitor and supervise the value of that particular asset. So if the committee of creditors agree, then they can also continue or they can also become the members of the committee, managing monitoring committee.
So Sandeep ji is asking that the RP has a maximum ceiling of a fee, but can other members of the committee also get any payment?
The
Have you
bank,
seen any IMC
the,
where others get a sitting fee?
the banks have decided that their members will not take any fee. And in case, however, in case they want any fee, that also has to be part of the resolution plan. The Of course, the all this amount, all these uh, kind of expenditure will be met by the successful resolution applicant as a part of the implementation of the resolution plan. Now, for example, if a resolution plan says that the entire construction project would be completed, then they can also say that there should be some full-time monitoring professional who would be helping the construction project. That they can also make payment to that person over and above the RP. But then it is all depends on the decision of the committee of creditors. But there is no bar who can take fee and who cannot take fee. There is only one bar on the RP that he cannot take fee more than what he was claiming as RP.
Then what are the powers available, rules and responsibility to monitoring committee in case of default in payment as per resolution plan? So what can the monitoring committee do?
Now, I have just found one judgment from NCLAT, which says, because the monitoring committee submitted an application saying that we are finding some practical difficulties in implementation of the resolution plan. And the prayer was that they want to change the resolution plan to remove these practical difficulties. The adjudicating authority rejected that. Then the appeal was filed before the NCLAT. So Justice Ashok Bhushan actually gave an order that we have not seen any kind of powers that actually can be given to monitoring committee for modifying the resolution plan. That has been the judgment, that the monitoring committee has no powers to modify the resolution plan. However, the directions were given to adjudicating authority that in case there is any practical difficulty in implementing the resolution plan, the adjudicating authority was directed to look into this. That is a very small judgment, but yes, I also understand that the monitoring committee cannot change the resolution plan. In case of any default, the monitoring committee can only go to NCLT. NCLT can monitor, but monitoring committee cannot.
All right. Then we have Ramesh Bhosleji saying, can monitoring committee use its discretion in waiving minor delays in implementation of the plan? So almost the same question.
Almost the same
Yes.
question. I would say that the monitoring committee does not have any power to change the resolution plan. What I understand.
Can the monitoring committee on the other side help in recording some kind of an agreement between the RA and the financial creditors on, some small delay?
No, they can record, but according to my understanding, after even facilitating the implementation of the resolution plan, normally there are, in many resolution plan approval orders, I have seen that the monitoring committee has been directed to submit periodic status report. In those status report, the monitoring committee should also mention any kind of non-compliances, any kind of delay, which the committee has decided amongst themselves to approve. That will also be considered as kind of ratification by the adjudicating authority. Also, what my suggestion is that in case it is very minor delays, then the monitoring committee should discuss this and then file a ratification application to adjudicating authority. Once we have an order from NCLAT that the monitoring committee does not have any power to modify the resolution plan, then even a delay by 1 day, that also will definitely need ratification. So according to my understanding, that ratification should be done. However, practically, if nobody is a complainant, if everyone is satisfied with these few days delay, I think the status report should be filed before adjudicating authority, mentioning all that. Otherwise, anyone can come against the resolution professional who is part of that monitoring committee, that this resolution professional used a power which he doesn't have. Yes, Ankit.
So then there is a question from Mukesh Ji. He says frequency. He is asking what frequency of monitoring committee meetings and any laws or judgment on the same. So there is no frequency. It can be totally as per the requirement.
Yes.
One can choose not to have any monitoring committee meeting for months, and then one can have a meeting. However, it is recommended that frequent meetings are done so that at least let's say there is a payment deadline, payment due on, let's say, 90 days, 180 days. So in case the payment comes in and the same can be recorded in the IMC that this is how it was completed, the process was completed, that's a better idea.
Also, in the resolution plan, in case the case is a complex case, then it can be provided in the resolution plan under the chapter of monitoring committee that the monitoring committee will at least have a meeting within one meeting in a month or one meeting in 15 days. That can be provided in the resolution plan, and then it becomes something mandatory for the monitoring committee to adhere to.
Then Mr. Dhupar is asking that what is the authority monitoring committee head what is the authority monitoring committee head to seek documents from RP who will sign the financials after approval of plan during implementation? So the
The
monitoring
financials we
committee,
can just.
I guess in this case, the monitoring committee is without the RP. So what Mr. Duper is asking is that monitoring committee is asking the RP to provide documents, and then he's also asking that where monitoring committee does not have the RP in it, who will sign the financials after approval of the plan during implementation? So while directors are not appointed in the company, who will sign the financials in case the RP is not there? RP has left office, IMC chairman or IMC member is RP is not the IMC member. That's the question that he's posing.
So the first thing that I would say, the the law says that the company cannot stay without board of directors. The board of directors was continuing till the resolution plan is approved by NCLT, although their powers were suspended, and for that interim period, the powers were in fact was used by the insolvency professional, RP or IR. Now, once the resolution plan is approved, the powers of the RP is all closed. Then the powers are with the RP. RP has the power to appoint the new management as directors. And once the new management is appointed, then handing over the control to the new management is something that the monitoring committee can decide. But my suggestion is, and the law also provides this, that the company immediately, the new management should be constituted once the resolution plan is approved. There is no reason that the new management is not constituted, the new board is not constituted. There is no reason. I still feel that some committee of creditors are saying that till the time they pay first tranche of the payment, they should not be made as a director, they should not be allotted shares. So what I'm saying is, as far as the allotment of shares is concerned, that I still feel okay. But the constitution of board, that should be done. By constituting a board, nothing is handed over to them because everything is with the monitoring committee, because the RP gives the handover to the monitoring committee. Then the monitoring committee will hand over it to the successful resolution applicant as per the terms and conditions of the resolution plan. Now, in some cases, I have seen when a new insolvency professional is made as the monitoring agency, the new IP will seek a lot of information from the RP. Now, let us understand what kind of information the new insolvency professional can seek from the RP. He can all seek the information which is required for implementation of the resolution plan, including the claims submitted by everyone. Because see, the claims are kind of admitted at times without even having the access to books of account. When the resolution plan is finally implemented, it is the duty and also it is the rights of the resolution applicant to re-verify the claims and also the documents. Also to see if there are any errors made by the resolution professional. So therefore, all the claim documents can be asked by the monitoring committee. Any other document which is required for implementation, that can also be asked by the monitoring committee from the RP. Yes, Ankit.
Then question from Mukesh ji, that is the role of the RP, the monitoring committee, counted as one of the assignments in the 10 assignments that an RP can take? I
No,
don't
it
think
is
this
not.
is counted.
No, it is not.
It is not counted. Then if the fees
So
of the chairman,
I also have a feeling, Ankit, if the even if the any insolvency professional is not having AFA, even then the person can be appointed as the monitoring committee member or monitoring committee chairman. Because see, if a person is continuing as RP, that of course is okay. If the person is the management, the committee thinks that this person can be appointed as the monitoring professional, even if he doesn't have AFA, he can still be appointed because the committee can appoint any other person. Committee can appoint any other person. When the committee is appointing RP or the IP, and the RP or the IP doesn't have that AFA, but any other person can also be appointed. So that same person can be appointed as any other person. So I don't think even AFA is required for appointment as monitoring committee member or monitoring committee chairman.
Okay. Then if the fees of the chairman or either members of IMC is to be disclosed in resolution plan, or it can be decided later. It can be decided later. It is
It can
not
be
required to
decided
be
later also.
disclosed.
It can be decided later.
Then question, then how many members minimum and maximum will be part of the IMC? And what is the qualification? Who is authorized to appoint other members? So it is, there is nothing which is stated. So it will be totally as per what the resolution plan says. But it has to be a logical committee. It cannot be too huge. It cannot be too small. It has to preserve the interest of all the stakeholders. That's the idea. Accordingly, the qualification and everyone will decide wisely on what should be the committee components.
Yes. Yes.
Can a related party be part of the IMC? Let's say suspended directors. Let's say somebody who kind of maybe the company is an operating is operational, and the suspended director is still giving his still cooperating and providing details with respect to allowing the company to manage itself or manage the operations. Can that person be part of the IMC?
I'm only trying to see one clause of section 29A that in case I can just find out, and that is the definition of connected persons. Now, when I see the definition of connected persons, Ankit, I think one clause may come into the way, because when I say section 29A, what we try to say is it is saying that the connected persons. Now, for the purpose of this clause, the expression connected person means any person who is a promoter or in the management or control of the resolution applicant, any person who is the promoter or in the management or control of the resolution applicant, any person who shall be the promoter or in the management or control of the business of the corporator during implementation of the resolution plan. Now, I don't think this can actually be considered as the members of the monitoring committee. With somebody who actually is having the control on the implementation of the resolution plan, at least should have 29A eligibility. That is what I could understand from the definition of connected persons under section 29 capital A. So any person who actually is managing the implementation, and if the monitoring committee is extending to say 3 years and the entire project has to be completed within this period, and we are making some person who actually is not having the eligibility under section 29 capital A, I think that can be challenged.
Right. Then another question, interesting take. So the idea is that let's say the representatives of the COC and the RA are part of the IMC. Now the question is, can the existing RP, some new IP, and another representative of the RP, can three people represent in an IMC? Now this is also maybe another way where the new IP can then also get his remuneration, and that remuneration will not have any barometer with respect to the existing RP fee. That is what is the
As I
question.
said, a committee of creditors can decide. The committee of creditors can appoint RP. The committee of creditors can appoint any other IP. The committee of creditors can appoint any other expert, or all the three. That all depends upon the committee of creditors. The committee of creditors and even can appoint all the three for smooth.
And they can then decide the
They
fees
can
for
decide
whoever is participating. So it's totally up to them. So they can actually look into other like other
Yes,
advantages like this also.
it is possible.
Then in case of home buyer companies, homes are built and to be handed over to all buyers. Similarly, all other claims are settled as per resolution plan. However, one on debtor has to pay to resolution plan, but there is a litigation is under a legal forum. Can we reconsider? Can we consider the plan as overland liquid the company as? I don't know. I think I will have to skip this.
No,
So
I think
AA
there is
has
a one I think relevant answer that is coming in my mind, Ankit. One, I have seen a judgment. I will come to the judgment, although the time is almost over. One judgment says that the monitoring committee can also extend its role to the recovery of debts of the corporate debtor during implementation of the resolution plan. The monitoring committee has also filed Section 7, Section 9 applications against the debts of the corporate debtor. It has been permitted by the adjudicating authority. Yes, the monitoring committee has the power to file applications under Section 9 or under Section 7 to recover the debts of the corporate debtor, because the recovery of the debts of the corporate debtor is part of the resolution plan implementation. So that's a huge power. That's a huge power to the monitoring committee. I think in case the resolution plan is not implemented appropriately, the first duty which has been assigned to the monitoring committee is to immediately report the default in implementation and ask the adjudicating authority to liquidate the company. I think this was also part of this question, which we couldn't read properly because of the maybe misspellings and all. To liquidate the company on any default is the first duty of the monitoring committee. Monitoring committee is not constituted to decide on the modifications.
All right. Then I have a question from Mr. Chakravorty. Mr. Chakravorty is asking that if the company is sold as a going concern in liquidation, is there a process to appoint an IMC in that process?
No process of appointing a monitoring committee in that.
Can there be a prayer or a decision within the COC meeting or the SEC meeting that this kind of a committee should be made for successful implementation of the liquidation as sale of the company as a going concern in liquidation, and then AA can incorporate that kind of process in the process? Because a resolution plan or some kind of a takeover is anyways prepared in a liquidation as a going concern case.
Now, sale of the company as a going concern is part of the liquidation process. In the liquidation process, we actually have to issue a sale notice, and then we have to seek the bidding processes. And after the bidding, we actually have to issue a sales certificate. After issuing the sales certificate, we actually have to go to the adjudicating authority for various other directions which are required to the liquidator for handing over the company, to making the reconstituting the board, etc. So there is what kind of document, if there is an arrangement between the creditors and the successful bidder, and that arrangement can be documented as an agreement, and that agreement can also be submitted along with the application to the adjudicating authority, and then the adjudicating authority can pass an order where the committee can be constituted along with the roles of the committee and the powers of the committee. That is practically possible, legally possible, but it is only possible in case the adjudicating authority passes an order.
Right. Then there's a very interesting question from Mr. Suresh Kannan. He's asking that can IMC open new bank account for implementation? So we practically understand that IMC, have you opened a bank account during IMC? Because recently when we were trying to open a bank account during the company's resolution process, we faced a barrier from the bank, because the bank said that you have already filed INC 28, the company no longer, the status doesn't say in CIRP. So now our head office is saying that you complete the documentation as per the requirement. So then they asked a board resolution. So fortunately, the board was appointed, or rather in place at that time. So we sought the board resolution in favor, authorizing the RP to open the account, or rather the chairman of the IMC to open the account, and using that we were able to complete the bank's paperwork. So far, we have not witnessed that the IMC is able to give a mandate to somebody to open a bank.
So let us understand the first part of the practical problems while opening a bank account during the CIRP. During the CIRP, the banks will not ask for the documents of the directors. During CIRP, the banks will open an account based on the NCLT order of appointing the IRP or the RP.
And the status on the MCA after filing INC 28 in CIRP. So that status helps. Yeah.
Now, in case you change the status from the RP to the constituted board, then only the board can open a bank account. The board can authorize any person as the signatory. So in that case, all the documents of the board of directors would be required by the bank. Now, the third is that in case the RP has opened a bank account during CIRP and that RP is continuing to operate that bank account for the purpose of implementation of the resolution plan, because the proceeds of the resolution plan will fall in that bank account and it will be distributed again by the monitoring committee as per the resolution plan. Therefore, in the powers of the monitoring committee, while we prepare a resolution plan, there should be one power that should be mentioned, that the monitoring committee will have the powers to continue the same bank account and the RP will continue to operate that bank account for the purpose of implementation of the resolution plan. If that clause is there in the resolution plan, then it is covered, then you can continue as a result. But you rightly said that once the board is constituted, bank will say that let the board resolution is passed for opening a bank.
So I think if there is a judgment, you can quickly talk about that. I think that might be more important. In the meantime, what I will do is I will try and answer the questions, separately.
So I think, like, I'm only saying that we have a couple of judgments. Like on 2nd September 2024, we have a judgment from NCLT Mumbai Bench 5 in the case of Nagpur Nagarik Sahkari Bank Limited versus Great Wall Corporate Services Private Limited, and it simply says that yes, the like the entire paragraph says, because in this particular judgment, the trigger date was important, and up to the trigger date the monitoring committee will function, and after a particular date another monitoring committee will function. So that was also approved by the adjudicating authority. So there were in fact two monitoring committees, one up to a date and the second up to after that. That is also practically possible. So that has been the order which I said. And then in another order, again, Deepak, because all these orders that I'm saying, Deepak, Shida, and versus Anuradha Real Estate Developers Private Limited, and again uh, like it is all mentioned that the monitoring committee will be set up to supervise, implement the resolution plan and shall comprise so and so members. The monitoring committee shall be constituted within 15 business days of the NCLT approval date, and pending constitution of the monitoring committee, the resolution professional shall be authorized to exercise all his powers and shall observe all its duties in accordance with the code. Monitoring committee shall supervise the implementation of the resolution plan and shall file status of its implementation before this authority from time to time, preferably every quarter. Now, this kind of order, which says that till the time monitoring committee is constituted, RP will continue its functioning. So the apprehension that I had, that how the RP is continuing to operate the bank account, how the RP is continuing to hold all these assets and records of the company, and also what kind of status reports are required. So these kind of orders that I could find, so I actually framed my opinion. Yes, the RP has the power even to operate the bank accounts. So that's where I say. Then we have on 30th of August 2024, the NCLT Hyderabad. It is in the case of Kali Dindi Venkateshwara Raju versus Himarus Therapeutics Limited. In this case also, the adjudicating authority has actually held that on approval of the resolution plan, a monitoring committee comprising of an insolvency professional nominated by SRA, one representative of the RA and one representative of the COC. So this is a resolution plan where the insolvency professional nominated by SRA was appointed and not the RP. Now, similarly, the another case of 30th of August 2024, State Bank of India versus Coastal Energen Private Limited, where the NCLT Chennai, in fact, has held, and it is like the implementation and the monitoring committee. Upon the occurrence of NCLT approval date, a committee shall be constituted, which shall comprise of one nominee on behalf of the approving financial creditors, one comma the insolvency professional, as mutually agreed between the RA and the approving financial creditors. subject to agreement achieved between the resolution applicant and the insolvency professional on a commercial term. So here also it is not the RP, it is another insolvency professional. Then the implementation and monitoring committee. On and from the NCLT approval date until the effective date, the management and affairs of the corporate debtor shall be managed by the implementation and the monitoring committee. The implementation of the monitoring committee shall stand dissolved on from the effective date without any further action or deed required from the corporate debtor. The terms of the appointment of the members of the IMC, including the insolvency professional, and details of the functioning and implementation of the monitoring committee and appointed any other advice and appointment of any other advisor to the IMC, if required, will be finalized in the first meeting of the IMC after the NCLT approval date. So all these are the text taken out of very, very recent orders. Now, what exactly is this? The NCLT can also say that the monitoring committee will abolish at a particular date or at a particular event. It is also not something which is mandatory that till the time each and every claim is settled, the monitoring committee will continue. That will also depend upon the committee of creditors. So it is not really mandatory that the committee will, IMC will continue till all claims are settled. So there are cases where the committee will continue up to a particular event. Then the SRA will manage the show. So then we have an order from of 9th August 2024, State Bank of India versus Kiran Global Chem Limited. And in this case, in fact, as I said, in this case also there are two monitoring committees were made. So that's again a different case. The two monitoring committees, one up to a date and then second after some time. Then like similarly, I would also like to say another case. Let me see what is important so that I only say the. Now in this case where the NCLT Mumbai Court 3 says Jayesh Sangrajka, the RP for Nirmal Lifestyle Reality Private Limited versus Asan Corporate Solutions Private Limited. And in this case, the order says, in view of the law laid down by Honorable Apex, the commercial wisdom of the COC is to be given paramount importance for approval rejection of the resolution plan. As the resolution plan meets the requirements under the code and regulation, the same needs to be approved. Accordingly, the resolution plan is approved with following directions. 1. Monitoring committee shall supervise the implementation of the resolution plan and shall review the operational performance of the corporate debtor. The resolution professional shall stand discharged from his duties with effect from the date of this order, save and accept those duties which are enjoined upon him in the monitoring committee. So in case of this Kridan Infrastructure Private Limited, in fact, this was 1st March 21 order. The Supreme Court has also commented on the powers of the monitoring committee. The Supreme Court, in fact, said that yes, the monitoring committee's role in such cases includes oversees the compliance of the resolution plan. But that is the monitoring committee said that this particular default should have been reported by the monitoring committee. And then I actually would like to see this. So all these are similar judgment. Give me 1 minute, Ankit. I actually have this one judgment from NCLT Chennai bench, which is slightly important. On the role of the monitoring committee. The monitoring committee was instructed to ensure the implementation of the resolution plan. However, upon the resolution applicant's failure to make the full payment, the monitoring committee was required to immediately file for liquidation. It was clearly established that the monitoring committee does not have the authority to negotiate or grant extensions for payment beyond the terms of the resolution plan. NCLT held in this case, the monitoring committee had no discretion to modify the terms or grant additional time for payments. So this is the judgment that I was looking forward to. Another judgment which is important again is from the NCLAT principal bench. That's in the case of Muhammad Nazim Khan versus Red Hex IT Solutions Private Limited. And in this case, the legal issue before the NCLT was whether the monitoring committee can seek amendments to a resolution plan post approval to facilitate its smooth implementation. The judgment says the NCLT upheld the rejection by the adjudicating authority, emphasizing that the post approval no amendments to the resolution plan are legally permissible. The court referred to clause of a resolution plan which allows modification only in specific situations such as unenforceability or invalidity of a provision. Since there was no such issue in this case, NCLAT ruled that the plan did not require modification. However, it acknowledged the practical difficulties raised by the monitoring committee and allowed the applicant to seek directions from the adjudicating authority to resolve implementation issues. So that's what I said, that the power to modify a resolution plan is not with the monitoring committee, but it is with the NCLT. So now, in one case, this is a case dated 3rd of June 2022, and the name of the case is Educomp Infrastructure and School Management Limited, through the chairman of the monitoring committee versus Millennium Education Foundation. Millennium Education Foundation. Now, in this case, the legal issue was whether the monitoring committee of the corporate debtor has the authority to file a CIRP application under the IBC against another corporate debtor. Now, the judgment in this case says NCLT New Delhi bench ruled that the monitoring committee is indeed a recognized entity under the IBC as defined in section 2, subsection D of the code. The chairman of the monitoring committee was properly authorized to file an application in order to protect the interests of the applicant, that is Educomp Infrastructure and School Management Limited. The court directed that the operational creditor may be served notice and the proceeding continued. One thing that I want to say, this circular of Ministry of Corporate Affairs dated 6th March 2020 on INC 28, filing of INC 28, in that circular itself, I could read that the no other forms would be enabled for filing by the IRP RP liquidator in his role of designated CEO unless the INC 28 is approved. Now, IRP, RP, or the liquidator in his role as designated CEO is again required to file E-Form INC 28 upon the approval of the resolution plan, initiation of the liquidation proceedings, or upon withdrawal of the application for CIRP, based on which the status of the company would get suitably reflected in the company master data. Then it says that in a scenario where a new board of directors is required to be appointed in terms of the order passed by the NCLT or NCLAT, the details of the first authorized signatory of such board of directors is required to be inserted by the ROC after receiving an application from the IRP RP liquidator. That's what I said, that the first authorized signatories that would be of the board of directors that would be inserted by the ROC after receiving an application from the IRP, RP or liquidator. And the SRN of the relevant E-Form INC 20 is required to be quoted. Consequently, the authorization for IRP, RP liquidator to file documents on behalf of the company will cease. And the new authorized signatory will take over the responsibility of filing E-Forms on behalf of the company. So this is what is actually very important. The ministry further, in fact, clarified that the company into CIRP or in liquidation is stayed. If that is the order is stayed or set aside by the NCLT or NCLAT or any other court, such order is required to be filed in Form INC 28 by the concerned IRP or the RP or the liquidator. So that's what is, Ankit, I wanted to say. So these are the, although there are many other judgments, but I only have said the relevant judgments today. In fact, all other judgments, that was basically for us to frame our opinion, to form our opinion on various questions that we answered. In case there are any further questions that we can still answer, although we are already 10 minutes over.
No, I think we should stop here. I have tried to answer as many questions as I could, and there are, of course, still some unanswered questions. So I will request, those participants of ours to perhaps just email the questions to us separately, or rather message them to us so that we can kind of revert on the same.
But we can always say, Ankit, that we are a full-fledged insolvency firm now, and in case there is any consultancy required, we are open to provide any consultancy to any of the attendees or any of their clients. So again, like I say that when we prepare such, when we study, when we do research, one, that it is our way of learning, as we always say, and we always respect everyone who actually gives us this motivation to continue. Now we are at 126th episode without fail every Saturday at 11 a.m. So thank you very much, participants, for giving us this encouragement.
Thank you. Thank you. Thank you, everyone.